and that the operations were permitted under Department and FBI policy because their use was not for the sole purpose of monitoring activities protected by the First Amendment or the lawful exercise of other rights secured by the Constitution or laws of the United States. We did not find documentary or testimonial evidence that political bias or improper motivation influenced the decision to conduct these operations. Additionally, we found no evidence that the FBI attempted to place CHSs within the Trump campaign or report on the Trump campaign or to recruit members of the Trump campaign to become FBI CHSs. However, we're concerned that under applicable FBI and department policy, it would have been sufficient for a first-line FBI supervisor to authorize the sensitive domestic CHS operations undertaken in Crossfire Hurricane, and that there is no department or FBI policy requiring the FBI to notify department officials of a decision to task CHSs to record conversations with members of a political presidential campaign. We concluded that current department and FBI policies are not sufficient to ensure appropriate oversight and accountability of such operations. One investigative tool for which department and FBI policy expressly requires advance approval by a senior department official is the seeking of a court order under Phiza. When the Crossfire Hurricane team first proposed seeking a Phiza order targeting Carter Page in mid-August 2016, FBI attorneys assisting the investigation considered it a close call, and a Phiza order was not sought at that time. However, in September 2016, immediately after the Crossfire Hurricane team received reporting from Christopher Steele containing allegations regarding Page's alleged activities with certain Russian officials, FBI attorneys advised the department that it was ready to move forward with a request to obtain Phiza authority to surveil Page. We concluded that the Steele reporting played a central and essential role in the decision to seek a Phiza order. As we describe in our report, the Phiza statute and department and FBI policies and procedures have established important safeguards to protect the Phiza application process from irregularities and abuse. Among the most important are the requirements that every Phiza application contain a full and accurate presentation of the facts, and that all factual statements are, quote, scrupulously accurate, close quote. We found that investigators failed to meet their basic obligation that the Phiza applications be scrupulously accurate. We identified significant inaccuracies and omissions in each of the 4 applications, 7 in the first Phiza application, and a total of 17 by the final renewal application. As a result of these significant inaccuracies and omissions, the Phiza applications made it appear as though the evidence supporting probable cause was stronger than it actually was. We also found basic, fundamental, and serious errors during the completion of the FBI's factual accuracy reviews, known as the Woods procedures, which are designed to ensure that Phiza applications contain a full and accurate presentation of the facts. Department lawyers in the court should have been given complete and accurate information so they could have meaningfully evaluated probable cause before authorizing the surveillance of a U.S. person associated with a presidential campaign. That did not occur, and as a result, the surveillance of Carter Page continued, even as the FBI gathered evidence and information that weakened the assessment of probable cause and made the Phiza applications less accurate. We concluded that as the investigation progressed and as more information was gathered to undermine the assertions in the Phiza applications, investigators did not reassess the information supporting probable cause. Further, the agents and supervisory agents did not follow or even appear to know certain basic requirements in the Woods procedures. Although we did not find documentary or testimonial evidence of intentional misconduct, we also did not receive satisfactory explanations for the errors or the missing information and the failures that occurred. We are deeply concerned that so many basic and fundamental errors were made by 3 separate hand-picked investigative teams on one of the most sensitive FBI investigations after the matter had been briefed to the highest levels within the FBI, even though the information sought through the Phiza authority related so closely to an ongoing presidential campaign, and even though those involved with the investigation knew that their actions were likely to be subject to close scrutiny. This circumstance reflects a failure not just by those who prepared the Phiza applications, but also by the managers and supervisors in the Crossfire Hurricane chain of command, including senior FBI officials who were briefed as the investigation progressed. Oversight by these officials required greater familiarity with the facts than we saw in this review, where time and again during OIG interviews, FBI managers, supervisors, and senior officials displayed a lack of understanding or awareness of important information concerning many of the problems we identified. That is why we recommended that the FBI review the performances of and hold accountable all individuals, including managers, supervisors, and senior officials, who had responsibility for the preparation or approval of the Phiza applications, as well as the handling of the rules procedures. Additionally, in light of the significant concerns we identified, the OIG initiated an audit last week that will further review and examine the FBI's compliance with its Woods procedures and Phiza applications that target U.S. persons in both counterintelligence and counterterrorism investigations. The OIG report made a number of other recommendations that we believe will help the FBI more appropriately use this highly intrusive authority, and it will also strive to safeguard the civil liberty and privacy of impacted U.S. persons. We will continue as an OIG our rigorous independent oversight as these processes move forward in the months and years ahead. That concludes my prepared remarks, and I look forward to answering the committee's questions.
Thank you, Inspector General Horowitz. These Greek names are hard. I just want to give you the opportunity. You made the same mistake I did. I started saying George Stephanopoulos, but you really meant George Papadopoulos.
Correct. Correct. Okay. And my apologies to George Stephanopoulos if that's what I said.
Mine as well. Before I start the clock on me, I did want to provide some clarity. I was going to do this in my opening statement, but I think it's best with just a quick little exchange here. In a number of places, not only this Inspector General's report, but also in the mid-year exam, you have a similar statement. I'm going to quote: "We did not find documentary or testimonial evidence that political bias or improper motivation influenced the decisions." Fill in the blank. You used it in a number of cases. Now, I know we talked earlier about you're pretty confident there was no political bias in the opening of the investigation with Bill Priestap.
Yeah, we did not find evidence, and as to him, we knew who made the decision. We could focus specifically on him.
But you definitely, in both these investigations, you found political bias.
We found, through the text messages, evidence of people's political bias, correct.
Also, political motivation. For example, Bruce Ord talked about how Christopher Steele was desperate to make sure that President Trump didn't become president.
Well, as to Mr. Steele, that was, of course, a very important part of this discussion, is when they understood his motivations and his potential bias. And we have the November statement from Mr. Orr that he had been told by Mr. Steele that he was desperate to prevent.
So again, so you're not denying there's certainly evidence of bias, there's certainly evidence of political motivation. But what you're saying, this is what I want to clarify, because I think this has been misconstrued and misused, depending on where you put it, that you're not saying that that bias did not potentially influence that. You're just saying you had no evidence that it did. Is that an accurate statement?
We have no evidence that it did. We laid out here what we did to find bias or evidence of bias. We put this report out here so the public can read it, look at the facts for themselves, but we did not find exactly what we said, documentary or testimony evidence of bias. But nothing again, more, nothing less.
But you're not saying you did not, that it did not. You didn't find evidence that it did, but you also didn't find evidence that it did. You're not saying that this bias or motivation did not influence. You're not making that declarative conclusion, correct?
Again, I want to carve out the opening and the predication.
Priestap versus the others.
Because because that decision was isolated, was made by one person. We knew who made the decision, understanding that there were questions raised by people above and below him. As to the other decisions, for example, the Phiza decisions and the errors and the problems, we don't reach a motivation conclusion precisely because of the concerns we have on that. So I think it's important for readers to read the report themselves. We talked about this before the hearing. Our job as inspectors general is to do what I know all of you expect us to do, transparency. Get the facts out there. And that's what we've tried to do here.
So you're leaving it up to the reader, to the American public, to judge whether the bias and motivations you have uncovered, to what extent did that potentially influence decisions throughout this process?
We're drawing the only conclusions we felt comfortable drawing here, and the public can read, and an informed public is very important for all of these purposes.
So just one final follow-up. What kind of evidence would you require? I mean, literally an oral confession or a text saying, you know, I so hate this guy that I'm going to choose this path versus the other. So
it was very hard to look at all this evidence and obviously, as we all know, get in people's minds. What was the motivation for decisions to be made? What we looked at was who touched the decision. Did we find evidence through text messages, emails, witness interviews? We sometimes do get, not in this case, but we do sometimes get whistleblowers and other people coming to us and saying, I think so-and-so made a decision for improper purpose. And we as IGs look at that. We were looking for that kind of evidence. As you noted, as to some people, we had concerns about that. Our last report lays out not just as to, for example, Mr. Stroke or Ms. Page, but as to others, concerns about certain text messages. What we were trying to figure out is, what was the evidence? Who was involved in decisions? And was there evidence linking those biased texts or other evidence connected to decisions? Could we bring them together? That was what we were trying to do.
I know in your report, you can start the clock now. In your report, you say the text messages were not only indicative of a biased state of mind, these are the struck page texts, even more seriously imply a willingness to take official action to impact Trump's electoral prospects. So that's a statement I also made. Okay.
Mr. Chairman, details maybe just a moment.
Sure. Stop the clock.
Is it fair to say that there are FBI agents who were pro-Trump and anti-Trump, including some fairly senior people who were pro-Trump and made it very clear that they were?
We found in both reports evidence of political views disassociated from action. And I think that's very important, and I tried to emphasize this last year as well as last week. We're not concluding that someone's biased simply because they supported one candidate or another. Frankly, they shouldn't be using their devices for any purposes that are political. It raises Hatch Act potentially and other issues that are not biased but other legal issues. But what we're looking at are, were the comments so significant that it concerned us that they might have caused them to influence decisions they made. And that's where we, particularly in last year's report, where we had far more evidence of text messaging. We had some people who had expressed political views but didn't act on them. Again, here we have some members that we have in here that reference their political views, but no information, and they're not the kind of written texts that suggest a potential state of mind that would cause us concern.
I think we have that covered. So my first question, and I'm not asking you to speculate, but based on your knowledge of FDA policies regarding investigation closures, and also based on what you found out that the FBI knew pretty early in the process of that consensual monitoring and what they found out once they finally interviewed the primary subsource, would it have been consistent with FBI and Department of Justice guidelines to close Crossfire Hurricane shortly after the FBI first interviewed Steele's primary subsource in January 2017? And would that have been a reasonable discretionary decision?
So certainly one of our criticism that we've laid out here is that as the team was gathering this evidence as to the Carter Page Phiza in particular, they weren't reassessing it, including, primarily, as I'm sure we'll talk about, the information from the primary subsource that was inconsistent with the Steele reporting. We even have in here in the report a reference on page 212 where we've got agents talking with one another about why is Page even a subject anymore. To your question of why are they still looking at him, they were actually asking that question not just as the Phiza, but the foundational question of Carter Page, we're not finding anything as to him. Why aren't we reassessing?
So again, my would have been within their guidelines. Would that have been if they'd done that and you were doing investigation, you go, That was a reasonable discretionary decision to close this thing down.
As certainly as someone who's done these cases in the AUSA and working with agents, if you're